Hello everyone, my name is Eleanor Lewis and I'm a research analyst for the Legal GC Powerlist and Private Practice Powerlist team. I'm happy to welcome you all to the second part of this webinar series titled Innovation and Competition Law, which will cover a broad range of issues regarding how innovation considerations affect or should affect competition law assessment. I'm delighted to introduce our speakers for today. Dr. Jorge Padilla is the Senior Managing Director and Head of Compass Lexecon Europe, Professor of Competition Economics at the Barcelona Graduate School of Economics and Research Fellow at the Centro de Estudios Monetarios y Financieros. Apologies if I didn't say that very well. And Mrs. Rachel Brandenburger, who is the Senior Global Advisor to APCO Worldwide, a visiting research fellow at the University of Oxford's Institute of European and Comparative Law, and a non-governmental advisor to the International Competition Network and the Executive Committee of the New York State Bar Association's Antitrust Section. And our moderator today is Mr. Gönenç Gürkaynak, founding partner of ELIG Gürkaynak Attorneys at Law, and I will now hand over to him.
Super, thank you very much. Jorge, your name turned into George somewhere in there. Sorry for that, but
it reminds me of my days at Oxford. So I think that I was Jorge Padilla.
I was just going to say, but you should hear what people do with my name. So, thank you very much to both of you for accepting to spare 1 hour of your precious time. And this is a very stimulating, interesting topic as well. We're talking about innovation and competition law today. And without further ado, allow me to start with Rachel in her broader remarks in landscaping what is close to her heart, what she feels is particularly critical in analyzing the role of innovation and innovation concerns and dynamic efficiencies in the context of competition law. I'm keeping it purposefully very broad as a question because we have decided that we're going to keep this fluid, and I'm hoping that as conversation gets cracking, we're going to find our questions and our particular drills and deep dives. So over to Rachel on this very first question.
Well, thank you so much, Gönenç, and thank you to you and to Legal 500 for the invitation today. Thinking about this topic, I think it's inevitable that I draw on the fact that I'm a lawyer with experience both in private practice and in government on both sides of the Atlantic. I happen to be talking to you from Brussels today. So, and when I was in government, I was a special advisor on international matters to the US Department of Justice's Antitrust Division, which is a big mouthful, but also, of course, a big honor. And maybe that's where I start. So I was trying to find some anchors for this discussion. So from the US perspective, I went to President Biden's executive order on the importance of competition to the American economy. And what do I find there right up at the start? And remembering this is an executive order for the whole of government, including the 2 federal enforcement agencies, DOJ and FTC. And I found a couple of very interesting comments. Robust competition is critical to preserving America's role on the world's leading economy. Point number 1. Point number 2, the American information technology sector has long been an engine of innovation and growth. A third point jumps out of this. It is also the policy of my administration, says President Biden, to enforce the antitrust laws to meet the challenges posed by new industries and new technologies. So those are perhaps drivers. Then I went, to be even-handed, to the European Union side of the equation, and I looked into a document that I remembered reading at the time, the DG Comp's publication on EC competition policy and EC merger control and innovation published in 2016. And it's quite interesting when you look in this because it's dated, this document. It says innovation is essential to increasing productivity in the EU, and this contributes to boosting growth and jobs. That's sort of similar to the US comment. The EU framework puts the competition harm caused by reduction in innovation on an equal footing with increased prices and reduced outcome. We know that. Then it cites goes through a number of interesting horizontal and vertical cases in pharma, energy, agricultural sector, some early data type vertical decisions as well. And then it says, which I think is more relevant to our conversation here, although we may come back and talk about some of those cases, and I'm sure this very knowledgeable audience knows which cases it's referring to. Then the brief says, at the same time, it says, EU merger control regime acknowledges that mergers may result in synergies arising from innovation. So on the one hand, it's saying anti-competitive. On the other hand, it says possible synergies. So and yes, we've saw some cases where synergies in innovation were acknowledged. But my question, I think, for us today is that still the case in 2023? Or are innovation benefits, synergistic benefits now becoming something that the agencies find very hard to acknowledge / are perhaps hostile to? ? I'm not making propositions. And let me leave my opening observations at that stage.
Super, thank you very much. Jorge, the same liberty of taking on the very first stab at this topic. What is most critical according to you? If you wanted to build on some of the things that Rachel has said, obviously, if you have another scope in mind, we can marry these as we go along.
Okay, well, thank you very much for the invitation. It's a real pleasure to be here with you and with Rachel. Thank you to Legal 500 for the invitation. So now we all know that innovation is key for economic growth and prosperity. It is the main driver of sustained growth. You can have growth by reallocating resources from inefficient uses to more efficient uses. But once you have done all those reallocations, end of the story, then then you have a situation of stagnation. So if you want to have continuous growth, you need innovation, and you need innovation not at once. I mean, you need lots of innovation and sequential innovation. And therefore, protecting innovation and fostering innovation is critical for our economies. And whatever measures we can adopt, those are good. And sometimes we do intellectual property in order to foster innovation. Sometimes we focus on subsidies and on prices. And of course, we have regulation and we have competition policy, and all those tools are, helpful and complementary in order to make sure that, innovation is fostered and protected, because that's critical for economic growth. Now, if we focus on competition law, I think that we also know that there is an interesting trade-off in terms of the relationship between competition, fragmentation, concentration, and innovation. On the one hand, we know that the more competition there is, the more innovation is likely to happen for two reasons. One is because, if there is competition, everybody's going to try to innovate to steal business from a competitor, whereas a monopoly has a limit in what its incentives to innovate, because sometimes the new products just cannibalize the existing ones. And so in order to escape competition, people innovate. And that's a positive thing. And that tells us we need to be aggressive enforcing competition laws to make sure that there is innovation. At the same time, we have to be careful not to go too far. Because if we go too far and there is no appropriability, then there are no incentives to innovate. If anything, and this is a relatively well-established fact, we know that there is too little innovation in society. And there, you could say, well, there is too little innovation because there is monopoly. Well, it's an explanation, and possibly it's true. But there is too little innovation because there are spillovers that are not internalized by those that innovate. They can be imitated. And not only that, I think that there is an issue about, I launch a new product, can I extract all the consumer surplus? When I launch that new product, that's very complicated. It requires a degree of price discrimination that is impossible in practice. So we want to intervene, but we need to be conscious and mindful of this trade-off. You know, it's we have a Goldilocks issue here. You know, we cannot go too far, we cannot be too short. And the last point I would say in these introductory remarks is that the problem that we have is that it's all complicated. You know, forecasting future prices, you know, as a result of a merger is difficult enough. But forecasting what is going to happen with innovation, oh my God, that's really complicated. It's impossible. No, nothing is impossible. You know, it depends on what is the degree, what is your tolerance for error. But you're going to make errors in one direction or the other unavoidably. And you have to think about which type of errors you want to, you know, protect yourself, you know, against in particular, and what is your tolerance? What is your tolerance for error? Now, if we think about this difficulty, it's difficult to think about what could be the potential effects of a merger, for example, on the incentives to innovate. But think about thinking or forecasting the potential efficiencies resulting from a transaction. Oof, very complicated. And not only very complicated, almost impossible for the agencies. Because let's think, what is the instrument that the agencies use in order to make sure that their forecasts about what a transaction, the effects of a transaction are? The main instrument that they use is the market test. So the parties say market definition is this. They say, go to people around consumers, competitors, and say, is this the right market definition? Yes or no? The parties say we are distant competitors. They go to the competitors and the consumers. Are they distant competitors? Yes or no? And so on and so forth. But they cannot market test efficiencies. It's impossible. It's impossible because of confidentiality. And this means that it's not only very complicated, more complicated than anything else, than price competition, the price effects, etc., etc. Also, it's very difficult to verify. And not surprisingly, they are skeptical about efficiencies. And they may be somewhat less skeptical about competitive effects because they can't market test them. Still, this complication, I think that is the reason why we're still debating. One final point, if I may. We want the agencies also to be innovative. Okay, it's not only that they should protect innovation, they should be innovative. But at the same time, sometimes we criticize them when they are too innovative. And it reminds me something something that I was told once by an entrepreneur here in my country when I told him, you know, but come on, I mean, not surprisingly, you're having difficulties because you are not innovating enough. He said, no, Jorge, I'm all for innovation, but nobody has done this before. And I think that is the problem sometimes that we have. We want the agencies to be innovative, but then we say, but nobody has done this before. So we have to be careful when we criticize them. It's a difficult topic, and not surprisingly, they will make errors. We need to be tolerant with error.
Rachel, I think we get to the point of legal certainty and how to attain legal certainty in the murky waters of securing innovation. Because as Jorge said, innovation is difficult to articulate, difficult to quantify, difficult to market test from different angles. A question to you is, do you think there are some slam dunk improvement categories, that are so self-evident, so obvious that the agencies could take on? For example, you know, not enough emphasis on mid to long term. Are we thinking too short term on innovation matters, or would you say that's not a thing? But would you say that the agencies should be more open to innovation efficiencies type of defenses, or anything that jumps at you when you read these cases that are articulating concerns about innovation, or that are holding themselves out as protecting innovation, and you say, this seems to be a consistent issue, or this seems to need improvement as a theme? Is there anything that is quite obvious to you?
Well, I think it's an absolutely critical part of this. And although we're not in the same place, we're obviously on the same page, because as I was listening to Jorge, I was writing down legal certainty, question mark, impact on financing and sources of financing for investors in this totally uncertain world of what the regulators are going to do. And I also noted, risks for business. It's all very well saying this is all very difficult, and I completely agree with what Jorge is saying. And it's very challenging for agencies, but we risk chilling innovation and sources of funds for innovation, and yet we've agreed innovation is necessary to grow the economy. So where do you get some transparency and legal certainty into all of this? And you look at cases, but I think some of the positions that agencies have taken in the past are not necessarily positions they would take now. You look at some of the, in the mergers context, which is where there's guidance, you look at some of the mergers guidance that agencies have given, for example, the 2010 US horizontal merger guidelines, which are being revised now. We may see them at some stage. The 2010 guidelines, I happen to know more or less off by heart, because they were being worked on when I was at DOJ, and I was involved in that process from an international point of view. But more importantly, I think I'm right in saying it's really the first set of guidelines where there is a chunky piece on innovation in the horizontal context, and a statement that, competition often spurs firms to innovate. And then it goes on to talk about things that are probably quite obvious to us now, which is where there is a horizontal overlap. Then comes to your point about timing. Is that what's happening now? Is that in the near term? Is that in the longer term? Is it pipeline? Tests have changed in relation to pharma and so on. Compare that with the guidelines that the CMA put out, probably one of the most recent ones, and try and work out, or be the CAT, the Competition Appeals Tribunal, and try and work out what dynamic competition means when you're reviewing the Meta Facebook Giphy case. And it's very, very challenging because forward-looking analysis is always challenging. And this is perhaps the most forward-looking of forward-looking analyses in terms of anticipating the future, whether you're talking about merger or conduct. And by definition, innovation is something that hasn't really fully hit the marketplace yet. So I'm not sure I'm answering your question, Gönenç, but I'm sharing some thoughts.
Yeah. On that, Jorge, do you believe that there are in existence economic presumptions that you feel agencies are using when approaching innovation cases, like they're tending to use arrow predictions, and then they move from arrow predictions, would you say, or would you say they are keeping a neutral approach at the very beginning of a case where they're handling innovation cases? Would you say they feel that a certain effect, especially cannibalization effect, maybe on innovation, they feel that it dominates all other effects? So the minute they see that changes the landscape immediately. If you see economic presumptions in play, do you agree with them, or do you think something needs to be done in balancing it? And if you don't see any economic presumptions in place, and if you feel that it's a neutral starting point, should there be economic presumptions to begin with to ease the analysis in the innovation sphere?
Okay, I think that there are presumptions. I think that they are changing in nature, and I don't think that they should be presumptions. Despite I think that what you have been saying and Richard has been saying about legal certainty, I don't think that we know enough to generate per se rules or even rebuttable presumptions. Traditionally, I think that the agencies all over the world were very conservative when dealing with innovation. And to some extent, I'm thinking about merger control in particular. I think that intervention was limited perhaps to sectors such as pharma, where it was very clear where you had overlaps in innovation paths, and where you could see ways of remedying those potential anti-competitive effects relatively easily. You had ways of understanding, because of the nature of the industry, what was in the pipeline and what was going to come up, and therefore the extent to which a transaction could eliminate potential competition, with degrees of certainty. And other than that, my sense is that the agencies, by and large, in merger control, they just wash their hands as regards innovation, and they were focused fundamentally on price effects, and perhaps some consideration about innovation, but from the viewpoint of efficiencies, but not much more than that. And we know that transactions were not clear on the basis of efficiencies. So if anything, innovation considerations from the viewpoint of inefficiencies could be like the sugar on top of the cake, ice sugar on top of the cake to clear a deal. My sense is that has changed fundamentally, and now many agencies have a view that suggests, or they believe that mergers are bad for innovation exactly in the same ways that they may be bad for prices. That absent other efficiencies, you can have a structural presumption against mergers, not only on the basis of their likely effects on prices, but also on the likely effects of innovation. And that is true for direct competitors in innovation, for potential competitors of innovation, and for possible competitors in innovation, because it's not about even actual pipelines, it's about potential pipelines. And I wouldn't be surprised if the new merger guidance in the US and shrink or consolidate that presumption, which that there are a number of economists that claim that that's the consensus view on the profession, but I don't think that is the consensus view of the profession. I can see circumstances where mergers can produce anti-competitive effects in terms of reducing the innovations of the merging parties, but there are other situations where the opposite is going to happen. And we have some theory, but I don't think that we are to the point in which we can say that theoretical research is closed, and we are lacking lots of empirical evidence in order to be able to conclude one way or the other, in my opinion. Now, again, an agency may be more tolerant with type 2 errors than with type 1 errors, and then they may put more emphasis in one thing to the other, but I don't think that we're at the stage in which we can develop a per se illegality test, or a per se presumption, or a structural presumption, negative structural presumption. We have one with cartels, but that's because we have a body of theory and a body of empirical evidence that demonstrates that consistently cartels are bad. I don't think that we're in the same position with respect to innovation and mergers.
And if I may just jump in here, from picking up on the presumption in relation to cartels, it's a certain type of cartel. It's not every cartel. It's from a US point of view, it's what one regards as per se, not something that could be subject to the rule of reason. Can I just throw something else in here? I expect everybody is aware of this, but the FTC's lawsuit last week, I think it was, maybe the week before, a few weeks ago, to block at the Amgen Horizon merger in the pharma sector, not on the basis of actual or potential or pipeline overlaps, but using something that the US used to say was completely crazy as a theory when the European Commission used it in things like GE Honeywell, and that is basically a portfolio and bundling theory. And so it's very innovative in terms of a theory of harm for a complaint. It is a long time since a US federal agency has sought to block a pharma merger, as I understand it, and it's really looking at Amgen's alleged unlawful business practices in terms of cross-market bundling and rebates and so on, and predicting what it would do if it acquired this target Horizon. So watch this space and see. It's very interesting to read the complaint and see what the courts make of it.
Rachel, do you think there's an issue with or a mismatch or an asymmetry, if you will, with the standards of proof and the burden of proof in the innovation sphere, in the sense that I very frequently think when the agencies are speaking with their decisions or statements of objections, they have a tendency to rely a lot on general economic theory literature, and they rely a lot on internal correspondences of the companies as well. But whenever the Defense Council is to put forward a dynamic efficiencies type of a case, and is to show dynamic efficiencies are there, they demand that it be case specific, it be verifiable, and that it is proven that it shall be passed on. So it doesn't feel like a level playing field if it is one animal of trying to protect innovation, right? Or would you agree with that? Do you think there is a mismatch in terms of innovation being used as a concern, being quite a powerful weapon, whereas when innovation is being used not as a sword but as a shield, as a defense for the Defense Council, then suddenly it is inarticulable, it is soft.
I mean, I think this is illustrating what we were discussing, which is the traditional frameworks that we've tended to use for antitrust mergers, but not only, are challenged in relation to innovation, more so than in any other area because of the unprovable, by definition, almost, forward-looking nature of things. What Defense Council, as you're depicting them as saying, it's sort of relying on what current decisional practice, core practice, guidelines, whatever, set out as the way of measuring efficiencies, which, as Jorge says, is usually pretty difficult to prove sufficiently, even in the non-innovation context. And what and agencies are perhaps realizing that they need a slightly different framework. They're very much looking at documents these days. They're very much looking at all the theory that displayed in the EU agribusiness cases, for example. And how do you prove or defend against to a sufficient degree of certainty for a judge, either because the judge is a decision maker or because the judge is a reviewer, depending on which side of the Atlantic you are, to be satisfied with the case? It's going to be if these US guidelines eventually see the light of day, and we don't know when they're coming, to see how they deal with issues like this. But I think you're absolutely right, Gönenç. I think there's a mismatch. It's almost like ships passing in the night in terms of what they're actually talking about. So they can't actually, connect and knock each other out of the process. Slightly linked to this, when I was preparing for this, I came across a very interesting, at least I found it interesting, article in the Antitrust Law Journal by Rich Gilbert and Doug Melamed. It's in the context of Section 2 of the Sherman Act, and it's called Innovation under Section 2 of the Sherman Act. And it's very detailed and thorough, as we would expect of those two esteemed authors. And it's to me, it started to answer some of the difficulty I was having as a lawyer of getting my head around how you use Section 2 or Article 102 in the innovation space, in the conduct space. It sets out a framework, doesn't have all the answers, but it tries to set out a framework for how to approach these issues. And what it shows us, apart from anything else, is there's not much framework in place at the moment.
Yeah, interesting. Thank you. Jorge, on this point, it seems that there is quite an agreement between the two of you, and I agree in that camp as well, that there has to be a holistic review of the market. And you know, if you were to just do an analysis that is too narrow, then that's just going to lead to erroneous, or there is a risk that it may lead to erroneous results. Two questions. One, do you think that the holistic review of the market parameters, especially in the merger control context, when there is an innovation theory of harm at play, can it be entrusted to the notifying parties, or do you think the agencies will necessarily have to explore the entirety of the market to be able to understand if the innovation theories of harm are really accurate? Whenever I'm involved in a merger control case where innovation theories of harm are being articulated, be it in the US, be it in the EU, the impression I always am under is that there's only so much the notifying parties can do, because so much of that innovation and so much of the contestability argument and so much of the market dynamics and, you know, whether you're a vulnerable incumbent or not, all of these, they depend on the rest of the market as well, and they don't have that data. Do you, as you are taking on so many economic analysis report tasks as well, do you feel the same way? Do you think there is an issue there? You're on mute, Jorge.
Sorry, there is definitely, and there is a difference with price analysis. I mean, to some extent, of course, what the parties tell you is, and the information that they provide you is very helpful. I mean, to understand to what extent they have innovation paths that are, you know, potential substitute that will lead to the potential substitutes in the market, and that will allow you to understand the extent to which a merger may end up with less competition in the future. So I'm not saying that the information that the parties provide is of no use, is of very significant use. But in the context of prices, we tend to think that whenever the parties increase prices as a result of the merger, the response of everybody else in the market is also going to be to increase prices. And therefore, to some extent, we can ignore that response. Okay, we think, okay, the parties are going to increase prices, they're close competitors, they are going to merge, prices will go up, everybody else will respond in the same direction. I don't think that we can make that presumption. We can have that presumption in the case of innovation. Maybe the parties innovate less as a result of the merger. Maybe that could happen. And then what's going to be the response of others? You know, economic theory doesn't tell you in an unambiguous way what would be the response of others. Maybe the response of others is to innovate more because now they see a window of opportunity. You know, and you know, we are more likely to be unique. Here we go. And I think that therefore is very important to understand what others are doing. Now, there is a second reason why I think that you need to understand what others are doing, which is in connection with not with horizontal mergers and innovation, but with vertical issues and innovation. You know, and here I think that we have Illumina Grail very recently, and a number of people saying, hey, we can innovate too. We can do wonderful things. But these guys control a critical input, and if they merge, they won't give us that. Okay, those are statements about the future, and you can take them face value, or you can try as an agency to investigate more. Investigating more is complicated because you have to second guess whether, you know, and whether they are telling you the truth or not, and it's complicated. How are you going to do that? The same problem that you had with efficiencies. How are you going to market test what these potential competitors are telling you? But at the same time, if you don't do it, you're exposed to, you know, getting lots of bullshit, if you I may put it that way. And I think that, you know, I wasn't directly involved in Illumina Grail. Some of my colleagues were, But my sense is that all those potential competitors, none of those have become a competitor. None of those has yet shown anything wonderful to the market. Maybe I'm wrong. But if that is the case, then some people were saying that they're going to enter and they were deluded. And should you prohibit a merger on the back of the delusions of some competitors? I don't know. It depends on what of the two errors you care about the most. And so I agree with you in terms of the general proposition that it's very difficult to take face value the innovation statements or pronouncements of the party, but it's also very difficult and dangerous to take face value what third parties may tell you. And if the agency wants to control errors, it's going to have to think about ways in which they can do proper market reconstructions, but not, it's already very difficult when you try to do that for market share calcul purposes, but for the purposes of assessing what is the innovation landscape.
This is a really important point.
Yeah.
I mean, it's unusual. Jorge and I actually had a case a few years ago that we were both working on, where the purchaser had managed to document that if it acquired the target, it would close down an innovation facility. You might recall, Jorge, that was being planned. So a smoking gun. And what did it have to do? It had to divest that facility at the end of the day to a third party. But, that's going to be, that's the easy case, so to speak, from an agency's point of view. But when you get into third parties' views of the future, and then their incentives, complex incentives in the antitrust case that they're in, and if you believe in due process of some sort or another, I think that is very challenging for agencies as to how to balance that all out.
Yeah. Rachel, on the matter of proof again, would you think that, so we've already established in the conversation that part of the challenge, if not the majority of the challenge, is coming from how futuristic the analysis needs to be. And that's always going to be the case. But as the degree of remoteness of the concern intensifies, as it gets farther into the future, should the standards of proof be higher in terms of articulating a concern for the agency? Put more bluntly, would you say that the earlier the stage of innovation is, the higher the standard of proof should be for a concern? So if you're going in with worries articulated about the discovery phase, it hasn't even gone into a phase 3. It hasn't been a phase 2 type of an innovation, but we're talking about the discovery phase of something, and it's in the remote future it's going to hit the markets maybe, and we're articulating a concern on it as the agency. Should it be a higher standard of proof, or would you say so long as there's an innovation worry, it should be subject to more or less the same type of evidentiary body?
So my instincts as a lawyer would say yes, the further out we're talking, the greater the burden of proof, the standard of proof should be. That seems like a logical answer. I'm not sure if it's the right answer, because I'm in the practical world, which I am a believer in as well as theory, because I would need to understand better than frankly I do the discussion of innovators and economists, what those, if one were sort of having a gradient, what is realistic evidence at a very far out stage that one could be expected for an agency to be looking for, or for the parties to be able to bring. So what you can make a statement about what the standard of proof would mean, but what can one actually show when one is so far out? Now there must be an answer to that question, in the same way as companies have to get approval to carry out a project, to fund a project. So they must need to show that it's not purely speculative.
Yeah.
But I would be careful not to create a theory that a standard that we lawyers think makes sense, that makes no sense from the evidence in the real world. Am I making any sense here?
Yeah, definitely. No, thank you. Oh, and my question was a bit theoretical. What I had in mind was, when I said higher standards of proof, maybe, requesting the agencies to make sure that the underlying assumptions of the economic literature they're using is applicable really in this case, and so that they move away entirely from all kinds of presumptions if it is a very far in the future kind of an articulation. Whereas if it is so imminent that this product is going to hit the market and there are overlaps already making the agency fear the cannibalization effect as well, then they're using more of the economical theory because they're feeling smug in the understanding that this articulation of cannibalization should amount to some concern. So yeah, I mean, I don't want to put words in your mouth, but
no, exactly. And I just think to put it slightly differently. I mean, this, as we were all saying, there's going to be an element of crystal ball gazing, speculation. All those words are loaded. And this is not a comment simply from a defense point of view. I don't think it's in agencies' best interests to be regarded as really working in an area that is so speculative that they could be regarded as, really not being answerable for what they're doing. So we do need some guidance, guidelines here. And, picking up Jorge's point, they may well need to develop over time, but we need some rigor in the analysis.
Yeah, if I may, I mean, this is a very difficult but interesting issue. I mean, if we think about time and we think that potential anti-competitive effects created by a merger may materialize not only in the short term, but also in the long term, and we think that there may be some hysteresis in the sense that whatever happens after the merger is going to carry on into the future, then I think that we should be more lenient with the agencies. Now, the opposite, in my opinion, is the case if we think that the merger may not have short-term effects, but perhaps with some probability is going to have adverse negative effects. And I think that we should be negative for a number of reasons. I mean, first, because it's much more difficult as you move into the future. The difficulties in forecasting compound. We can reasonably say what is going to be the inflation in our countries, within a month and possibly even with 6 months. A year becomes very difficult, and beyond that is super complicated. So that's one thing. But also because, and I think very importantly, merger control is not the only instrument at the disposal of the agencies.
Yeah.
So if the merger materializes and then it proves to be anti-competitive, there are other instruments. And in fact, I think that to some extent it's interesting to see what happened, I think that yesterday or this morning with the issuance, I think it was yesterday, the issuance of the statement of objections against Google in the AgTech matter. Because I've read it very quickly, I'm not involved, but I've read the press release. But it seems to suggest a potential structural remedy involving the potential divestiture of DoubleClick. Well, there was a merger many years ago called Google DoubleClick, and then and I remember I was against that merger. I worked against that merger, and I didn't manage to persuade the chief economist and the commission at the time that it was problematic. Now the agency seems to have a different view as a result of the accumulation of evidence that has been collected over the years. Well, it intervenes ex post. No, of course, ex post intervention is hard, expensive, etc. But perhaps from an ex ante perspective, that was the right decision to clear, see what happened, and then take the effort to prove with facts that something was wrong. So I think that there are reasons why, if you identify problems in a distant future, perhaps you need to wait and see for that future to approach us.
Yeah, I try to not vote about these things, although I admit I'm asking a lot of leading questions today. But I do agree with this statement, and it's so fresh and new, and it is linked to the new development in the Google AdTech matter, that I'd also want to underline exactly what you have said, which is that the fact that you have approved Google DoubleClick back in the day is clearly not excluding your enforcement abilities at a later date. I'm not saying that this enforcement is warranted. In fact, I'm involved in the case, so I shouldn't say much about the Google AdTech one. But all I'm saying is, underlining what Jorge has said, you are able to come up with issues with Facebook, WhatsApp, right? And when approving the Facebook, WhatsApp matter, actually the agencies, they do not know how the market is going to evolve and what is going to come out of this particular merger. So rather than engaging in too futuristic scaremongering, if it comes down to that, I'm not saying all enforcement comes down to that, but if it is coming down to that, it is of course a possible approach to take baby steps in the enforcement at the point of merger control and then see if things evolve in a certain direction. Because it really is fascinating to me to see that in academic fora or in professional fora, whenever people talk about the likes of Google DoubleClick or Facebook, WhatsApp, there is almost a preconception that it was wrong that these transactions were approved. And people nod and, you know, under enforcement, oh, yeah. But back in those days, we were all there. We're senior enough. We remember all of this. And the monetization of these products were not obvious. And how it was going to go through was not obvious. And there are so many other mergers that have happened in the past that failed that no one talks about it. And if those were not allowed, that was going to be perverse enforcement. So I think if I'm not taking too far what you have said.
No. If I may, we shouldn't be surprised. I mean, just think about it. I think that I'm going to create an analogy or talk about an analogy that I'm pretty sure that will be close to many of you. Many of us live in countries where it doesn't snow that often. And I think that that's true whether we are in the UK or we are in Turkey, and certainly it happens in Spain. But whenever it snows in these countries, we don't, and therefore, whenever it snows, we don't have the means to deal with it like this immediately, like the Finns would do. Okay. Mm-hmm. And what happens at that point in time? Everybody complains. Everybody complains very bitterly about the lack of foresight of the government. Yeah. Our societies, and compounded by the way that the media operate, etc., are very much into precautionary regulation. But of course, precautionary regulation involves significant costs. You want to be able to deal with that snowfall once every 5 years, once every 10 years, as efficiently as the Finns, you're going to have to invest a tremendous amount of money. And I think that the same occurs, mutatis mutandi, in the context of, competition intervention. Something goes wrong. Oh, I told you, you see, and you should have done something. And what you should do is prohibit everything that moves. Let's regulate everything that moves, and we're not going to care about the cost. For that event, which is a black swan event that happens with a very, very small probability, I think that we need to retain the flexibility of intervening ex post and not overburdening, our companies and our regulators with extensive ex-ante regulation for risks that when they materialize seem obvious, but ex-ante were actually pretty small.
But I think partly in this conversation is an implicit, if not explicit, concern about the difficulty of the tool for subsequent intervention, i.e. establishing a case under, in EU speak, under Article 102. Which is not easy. And I'm not advocating the ability to call in mergers subsequently under the merger regulation, under merger review. But I mean, there are jurisdictions around the world where even if you have filed and no action was taken against you, you're still subject to being called in subsequently. That's another instrument that could be.
That's a very good point. That's a super good point.
Yeah.
And also that tells you that I'm going to speculate here a little bit, but let me throw the following idea. That basically suggests that instead of being negative about remedies, we should be more general, more open-minded with remedies. But we need to have then proper monitoring and enforcement of those remedies ex post, with clauses that allow the regulator to do things, including to take structural decisions in the event that those remedies are do not work properly or are not properly implemented.
Let me transfer this one to you, Rachel, with my own notes. So exactly what Jorge said, I'm really wondering your view on it. In my notes even, I wanted to take the last bit here. So this is our closing remarks as well. I was saying, shouldn't the agencies accept to engage in complex remedy discussions in the field of innovation? So particularly remembering what Jorge said, we're expecting the agencies to be innovative as well. Doesn't it feel like they're at the moment not prepared to take on any remedy proposal that goes beyond traditional measures that address unilateral effects, basically? So it feels like whenever innovation theories of harm are articulated, the remedy proposals that are found acceptable are actually traditional measures that we've always seen in other cases that address the unilateral effects. And somehow, because the unilateral effects are addressed, there aren't that much innovation theory of harm concerns either. And the flip side of that coin is that the authorities are too quickly saying, in my view, oh, this is very difficult to monitor and enforce. Now, it being difficult to monitor and enforce is a flaw, obviously, on the traditional landscape. But when it is designed to address innovation theories of harm, isn't it natural that some of the complex remedies that are proposed will be difficult to monitor and enforce, and the authorities will need to embrace that fact if they want to find the fine balance that we're discussing here?
I think you make a really important point. I mean, we have agencies around the world that are either only willing to take the most relatively straightforward remedies, maybe only structural and not behavioral. We also have some agencies in the world, in the US, who don't seem to like any remedies at all at the moment, and want to litigate. Now, this is a point in time at which we are. I've been around doing this long enough that I don't think we necessarily, there's no likelihood of change in the future, but that's where we are now. That incidentally explains some of the divergences that we're seeing in terms of outcomes at the moment. It's really about remedies. I do think, having sat on both sides of the table, that the area we're talking about today is incredibly challenging, both for agencies and for parties, to try and get on the same page. And the thing that always worries agencies is that they haven't really understood. They won't admit it, but that they can't be confident that what is being proposed to them in a situation that, as we discussed in the first part of this conversation, is by definition very difficult, complex. Jorge said speculative. I think I said what the answer should be, and that they're not having the wool pulled over their eyes by some very sophisticated innovator. So shaping the remedy, crafting the remedy, testing it, even before you come to enforcement and monitoring, is hugely challenging. And then you have the practical, so you've got a knowledge issue, a resources, a confidence issue, a resources issue. But where do I go from this? Do I say this can't be done, so therefore you can't have innovation in the mix? That can't be right. So I think what you are highlighting, Gönenç, is this discussion needs to be as much about remedies as about theories of harm.
Yeah. Okay, any last words?
Two quick comments on my side. First, I'm scared when people suggest that due to the difficulties, the right solution to my medical problems is surgery. I prefer them to try other things. Okay. Yeah. And if that takes them a little bit more effort, let's do it. But you know, I don't want to go to the surgeon too quickly. That's the first point. And the second observation I would want to make is that at the moment, I think that there is a schizophrenia. And the schizophrenia is the following. We don't accept remedies in merger control, and we're not prepared to have behavioral remedies in merger control because we don't want to be regulators. Yet we want to be regulators, and we are asking for the DMA, the DMU, etc., etc. So what do you want to be? Do you want to be a regulator, or you don't want to be a regulator? I think make your mind. But if you're going to be regulating people, you know, digital platforms, complicated, huh? If you're going to be regulating ex ante, you're going to be monitoring those conduct. If you're going to monitor conduct there, why can't you monitor conduct elsewhere?
Yeah. Thank you very much. I had promised 1 hour time slot to you, and we are there. And this was full of content. It was extremely interesting for me as well. I hope everyone attending liked it. We're going to issue a link with a video of it as well, which also gets viewed very many hundreds of times. Thank you very much for sharing all of this knowledge, know-how, content with us. And I hope a good rest of your day and a nice approaching weekend to both of you.
Thank you so much.
Thank you very much. Thank you. Bye.
Thank you all. Again, this will be online on our website as well. And thank you all for joining, and to our speakers.